The purpose of this lecture is to explain to you the stages of a criminal trial and some talk to you about some of the actors that are in a courtroom. This you might want to print out, but you can see pre-trial, and then there's a trial down under adjudication. So we're going to talk about some of these stages, okay? But just remember, there's three stages to the criminal justice system, right? You have police. Those are the ones that gather evidence to you. They give it to the prosecutor, and if the prosecutor decides to go forward, then you would enter the court system, okay? And that's what we'll talk about. Then lastly, if you are convicted of a crime, you enter into the correction system. And I'm just going to apologize right now. My mouth gets dry doing these, so I will sip occasionally. Okay, we're going to go into the various stages of pre-trial stages in the next couple of slides. Please be aware that it can differ slightly depending on the state. Okay, and remember, there's federal court system. If you're charged with a federal crime, you go to the federal system. But the vast majority of street crimes that we think of, rape, robbery, murder, are state crimes, and we go through the state court system. Okay? So the first appearance, okay, is sometimes it's called an initial appearance, a magistrate's review, but the idea here is that it's their first appearance before a court, okay? Can be a lower court judge, it can be all kinds of ways depending on the place, right? But the basic idea is defendant hears the formal charges they're facing and their rights. Sometimes at this stage, they have the opportunity to post bail, okay? What is bail? Bail is basically a down payment, typically money, that assures that you will show up when your trial occurs. So basically, if you pay the bail, then you get to be out in the community under certain restrictions, but you agree to show up, right? But the vast majority of people can't pay the bail because it's too high. So they get a bail bonds. It used to be called a bondsman, or so you could have a bail bondsman or woman or bail. I don't identify as anything non-binary. Okay, a bond person. Okay, and they generally pay 10%. I'm sorry, you generally pay the bail bonds business 10% of the total. Okay, and then you agree to show up, and then if you don't show up, they're on the hook for 90% of that total. Okay, so if your bail is set at $100,000, you have to have $10,000 to give to the bail bonds business, right? It's very, very lucrative business. Okay, I had a classmate whose father owned a multi-state bail bonds business, and they were very wealthy. So that 10% that they keep adds up. Okay, so you may have, so if they don't show up, that's called skipping bail. And you may have seen that show called Dog the Bounty Hunter that's set on in Hawaii. So when Dog the Bounty Hunter is going to get somebody, it's because he's on the hook now for that 90% of the money. Okay, so that's why he goes and grabs them. There's also, so you know, a political movement to abolish cash bail. Because, as this should make just common sense, it discriminates against the poor, right? Bails, they're pretty high. So, you're talking thousands of dollars just for the 10%, right? And so the idea behind that was if you don't have the ability to pay, you're going to be sitting in jail awaiting trial simply because you don't have the ability to pay, not because you're a danger to the community or a risk of not showing up, right? But the judge is supposed to make a decision on bail when they set the bail based upon factors, right? Like what are you charged of? What's your criminal history? What's the probability that you're going to show up? In California, the primary thing they're supposed to be concerned about is public safety and the safety of the victim. Okay. There's also something called a grand jury. Okay, about half of states have a grand jury, and the federal government has it for felonies only. Okay, grand juries are basically private citizens who, I don't know how you get on it, but they're a group of private citizens, and the prosecution presents the evidence, and then the grand jury decides whether going to a trial is warranted. Defense, the defendant does not have the opportunity to be present nor present evidence. Okay. Um, so all they're deciding is whether or not it should go to trial. Okay. The preliminary hearing is used for states that don't have grand juries, but it's the same idea. Okay. Um, the defense presents the evidence before the judge. The defense gets discovery, which means the prosecution needs to give them their evidence. Okay. But a judge at this point, really, and the federal, what they sort of try to decide is what's called probable cause. So, is there a probable cause to believe that a crime has been committed, and probable cause that it was the defendant who committed it? Okay. So, essentially, the defendant hears their charges against them. The judge decides whether or not it should go forward. Okay. At this point, or before the main trial, um, there is something called plea bargaining, and we're going to talk about that on the next slide. Okay. So the arraignment and plea, this is the defendant's first appearance before the very court that's going to decide whether or not she's factually innocent or factually, I should not say that, sorry, legally guilty, right? So courts decide whether you're legally guilty or legally not guilty, not whether or not you did it. Okay, that's called factual guilt. So I apologize for that. So basically, the rights are read, charges are read, and the defendant enters a plea, which is guilty, not guilty, or no contest. No contest is sort of like, yeah, I did it, but you're not able to sue me for monetary damages in civil court later. Okay. Um, Plea bargaining is essentially a deal between the prosecuting attorney and the defense attorney. Okay, the prosecuting attorney will generally lower the charges if the defendant agrees to plead guilty. So I'll just make it up and keep it simple. Pretend you're charged with murder in the first degree, right? Prosecutor goes, tell you what, I'll lower it to murder in the second degree. Your guy please. Okay, so that's the bargain. And if he goes, okay, that's a plea bargain. Okay. The idea here is that the defense would agree if they feel their chances of winning trial are in doubt. Okay. So it's supposed to be win-win, right? The prosecutor gets a conviction and the state is spared the costs of a full-blown criminal trial. So in theory, it's mutually beneficial, right? Especially if you did it. Okay. However, it's become an institutional necessity. Okay. It's been estimated approximately 90% of all criminal convictions are arrived at via a plea bargain. One study, the latest one that I could find from the Bureau of Justice Statistics, is it was higher, closer to 95%. Okay, and only it was actually 94, and only 6% went to trial. Okay, so it is not a stretch to say that I'm going to steal a line from my professor, Professor Craig Haney, who is, you may have heard of the Stanford Prison Experiment, if you guys are in socials, anybody who's taken a social psychology class. It was Haney, Banks, and Sambarum, he was Haney, so he was one of the primary investigators. That's what it's called, the person who runs the study. So what's happened is, so if 90% of cases or convictions are arrived at, via a plea bargain. That sort of tells you that even if a significant amount of defendants insisted upon their right to a jury of their trial before the right of a trial before a jury of their peers, as Professor Haney said, the court system would come to a grinding, screeching halt. Right? They would have to have vast more money in order to. They're already slow, right? The courts are already backed up, and 90% of the convictions are from plea bargain. Okay, so if they were to eliminate it or even lower it to a substantial amount, the courts would just come to a grinding, screeching halt. You'd have to wait way too long. Okay, so there's either plea bargaining or you expand your court system. Okay, but it is very clear that you can say it is now an organizational necessity, and it's primarily due to fiscal or financial reasons, right? Meaning you don't want to expand the court system. Okay, first part of the trial. There's something called jury selection. There's some fancy, I believe that's Latin, voir dire. I don't know how to say it, voir dire. Okay, so what happens there, okay, is the jury needs to be selected. Okay, so there's a pool of jurors, and then the prosecution and the defense sort of go through them, and they have to seat the members, right? So the classical thing is there's 12 people on a jury, right? And so each side, it's an adversarial system, right? So in theory, both sides are equally powerful, have the equal resources, and they battle it out in court for something called legal guilt or legal innocence, which is different than factual guilt or factual innocence. Factual innocence, right? Factual guilt means you actually did it. Okay? Legal guilt means you're held legally responsible for it. So the prosecution's job is not to go, oh, did he really do it? I mean, that's at the pre-trial stages, right? That's when they decide that. But once they get to the trial, the prosecution's job is to get a conviction, and the defense's job is to get an acquittal or not guilty. Okay. There are three kinds of challenges. Okay, to the array, which is it's usually done prior to actually selecting the juries. They kind of go through this in big serious things, but it sort of tries to argue that the pool of applicants, the pool of potential jurors, are not representative of the community and biased in some way. When I grew up in California, it used to be based upon people who paid tax on property or owned a car registration. Those were the two things that they got the list, right? And if you were on either one of those lists, you could get a jury summons. So I don't know what it's like now, but you can sort of make that argument that, well, how's that representative of everybody? Most of the people are, there's a lot of criminal defendants who don't have any property and who don't even own a car. So how is this group of people going to be sympathetic, right? Or like them, a jury of their peers, right? So that's just, I'm not saying which way you should go on that. I'm just saying that's what you sort of try to do, is get the judge to get another group of people somehow. I am certain, though, you couldn't say, Judge, you guys get your list from property owners and driver's license people, and that's not fair to my client. That's not what I'm saying. Somehow, I guess they're saying whatever group of people they have to pick from, they have to pick from. In really fancy trials, they have the list of everybody who's a potential to be those 12 people, right? And they go through them with a fine-tooth comb. You may have seen that in the movies, okay? So the idea is each side wants to kick people off. You don't want to seat a juror that's going to be bad for your side, okay? So you want to pick people that you think are going to vote on your side. So I'll start with the last one called preemptory challenges. You don't have to give any reason. You have a certain number of them, and you could just ask the judge to use one of them and the person's kicked out, they go home, blah, blah, right? You're not seated. Okay? It's almost like a get out of jail free card, right? You get a number of them. Apparently, in a federal capital case, each side gets 20 of them. Okay, so that's death penalty, serious business. That's why they get so many. I don't know what each state does, etc., but you get the idea. Challenges for cause. Okay, basically the attorney argues that the juror can't be impartial or fair, right? So they'll ask you stuff like moral beliefs. Do you think it's what happened? So they try to figure out how you're going to vote, right? So, like for example, my grandmother, they said, Mrs. Hallstone, do you think you could fairly judge somebody who's accused of stealing a TV from somebody's house? And she goes, I think they should all be taken out and shot. And the attorneys, whatever, that's a reason why you excuse them for cause, right? By the way, if you ever did go and you didn't want to be seated, either sound like a raving lunatic like that, on that side of it, like my grandmother, or you could do I'm a criminal, like this whole thing is biased against poor people, and it's not, and they're going to let you go for cause, right? So basically you say, no, I couldn't be fair because I think the system's biased or whatever. All right. So those are the three kinds of ways that they kick them off, but then they eventually seat 12 people. Okay, so there's opening statements. Okay, you've all seen them in the movies. Okay, so that's the first opportunity for each side to speak directly to the jury. Okay, and they sort of tell them their story and their version of fact, and how they should vote based upon the evidence. Generally, the prosecution goes first, right? And then they have the burden of proof beyond a reasonable doubt. So to get a criminal conviction, they're going to need to prove it beyond a reasonable doubt. That's the standard. Remember, probable cause was the standard to get you to a trial. To get a conviction, you need to be beyond a reasonable doubt, what a reasonable person would sort of decide in that way. You and I know that that's very creative, and there's no objective definition of that. Okay. All right. So that's the first part of a trial. Okay. Each side will, after their opening statements, will present evidence. Generally speaking, the prosecution goes first. In fact, I'm almost positive of that. Somebody fact check me if I got that wrong. I'd be surprised if it's not the prosecution that goes first in all instances. So there's various types of evidence. Okay, you can have direct evidence, circumstantial evidence, and real evidence. I'll start with real evidence because that's the easiest. That's physical things such as fingerprints, tire tracks, documents, DNA, the actual murder weapon, right? Okay, there's direct evidence. It proves a fact without needing to draw inferences. It can be types of real evidence like photographs, video, eyewitness testimony. There's also circumstantial evidence, and it requires a person to make inferences. So, for example, pretend I'm a witness. I hear a gunshot. I run around the corner, and I see the defendant was holding the gun. It would be reasonable for me to infer then, assuming there's not a whole bunch of people with guns around the corner, that the defendant fired the gun. Okay? But it's upon the evidence, right? The judges define which evidence can be presented to a jury and which not. So this is very important because it determines the facts what the jury decides the case on, right? And there's all sort of rules and procedures here, which is beyond the scope of an introductory class. But I think you've all seen stuff like that in courtroom dramas, okay? Witness testimony is often a big part of it, okay? They're sworn in, right? Sort of tell the whole truth, damn truth, and nothing but the truth, right? Now, the Constitution says that the defendant, I think it is the Fifth Amendment, because I'm going to say why in a second. The defendant does not have to testify at his or her trial, okay? Now, the defense can decide to do it, okay? But then they're subject to cross-examination, okay? So you may have heard, I take the fifth. I take the fifth. That means you're invoking your right to self-incrimination. You do not have to testify, right? But in a court, if the defense puts you up, right, to testify, the prosecution is also going to get to talk to you. Okay, so that leads to what is direct examination and cross examination. Basically, when a side, I just gave the example of a defense attorney having the defendant go up, then me as the defense attorney, I get to do direct examination. I ask them questions. Then when I'm done, the prosecution gets a chance. We've all seen it, right? No further questions, Your Honor, in the movies. So that it can actually kind of go back and forth, right? But basically, that's why it's a really important decision for the defense as to whether or not they were going to have their defendant testify, because that opens them up to being cross-examined by the prosecuting attorney. Okay, so you have the trial. Each side presents their evidence. Then, after the last part is you have closing statements. You've all seen those in the movies. Okay, that's basically where each side tells their, they sort of retell their story. They tell you about what they did and why you should vote for their side, right? And basically, there's no other way that you could vote than this. It's clear, right? So that's the idea that both sides do that. Okay, then the judge will give instructions to a jury prior to their deliberations. That means they go in a room and think about it, right? And, depending on the court jurisdiction, he gives them, right? But he will certainly explain to them that to get a conviction, you need to convince that the defendant is guilty beyond a reasonable doubt, right? That's the criteria, okay? Many places require a unanimous verdict, okay? So that means everybody decides it. If a jury can't decide it, you have something called a hung jury. So unanimous just means everybody in the jury says yes or no, right? Guilty, not guilty. Sorry for guilty, right? If not everybody agrees to guilty, you have what's called a hung jury, right? And then various things can happen. The Supreme Court has ruled that only capital cases, meaning things that involve capital punishment is the death penalty, so only those require a unanimous vote. So that means if there hasn't been another Supreme Court case that said something different, that means states only have to do it need unanimous. They can have it if they want, if the legislature writes the law that way, but they don't have to have it except for if they want to execute somebody. Okay, this section, what we're going to do is we're going to talk about the various people, I call them, the actors who are in court, okay? It's not an exhaustive list, but I'm just giving you 6 main ones, basically, okay? So the judge, I think say the best way to think of that is they run the courtroom. Their job is they're the boss, right? And they're supposed to assure that justice, I'll quote here from a book, the honest, impartial, and equitable manner. So justice is served in like that. Okay. In sometimes lower court cases, the judge might decide guilt or innocence, but for the more serious ones, they generally have a jury trial, right? So like when you go to a traffic court, right, the judge, and you try to fight it, there's no jury there. Okay, so that's an example of a lower court. All right. Judges are either elected by a vote in some states or some jurisdictions, or they're appointed by somebody in the political thing, generally speaking, the governor, okay, and in the federal level, the president, okay. So, for example, federal judges are appointed by the president, and they must be confirmed by the U.S. Senate, and they serve for life or till they retire. In theory, they can be impeached by the House of Representatives, but it's only happened once on the Supreme Court. I don't know how many times it's happened in lower federal courts. And it was a long time ago, 1805. But an example of this, so remember, it's a very political thing who sits on the court, because depending on your political persuasion, you want your cases to be decided your way. So the appointment of a Supreme Court, generally speaking, the Senate grills them pretty hard. Okay, but you might have remembered in 2020, Justice Amy Barrett was confirmed in only 3 weeks on something like October 25th or 6th. Okay, it was like 9 days, 10 days before the election, right? Which was weird about it was that in Obama's last term, in the last year, I think in February, a justice died, Anton Scalia. Okay, and then the Republican side, which controlled the Senate, said, "Oh, it's not appropriate for us to um, consider a Supreme Court justice this close to a presidential election. Therefore, we should wait." And the president of the Senate refused to hold any hearings, and so basically, after that, Trump was elected, and then they were able to put judges on there that they liked. So think about it. That's the first thing that happens, right? It's in the last year before an election. It shouldn't be done. Then when a justice dies, it's in the month before an election. The same guy rushes it through, right? So obviously it was a lie, but it was brilliant, if not brutal, politics, right? Both sides will learn from that, Democrat and Republican, I guarantee you. Okay. But just remember, in some jurisdictions, judges are elected, right? But also in some, state level, they are also appointed. Okay, the prosecutor can be called many things. Okay, the DA you may have heard of, and you can see him there on the slides. District Attorney, DA, in the federal courts called U.S. Attorney. Okay, they're supposed to represent the government or the people. Remember, a crime like criminal law, right, is thought to be a crime against society. By stealing that car, you did not only injure the victim, you injured the fabric of society, so to speak. So that's why it's always the people versus, right, or the state of Hawaii versus, and then the last name of the defendant, right? And so that's the way that works. So basically, the prosecutor and the prosecuting office decides how to handle the evidence that's brought to them by the police. Okay? So they can decide to drop the case, to plea bargain it, or go to trial. So that's called prosecutorial discretion, and it's very powerful. Okay? You need people to provide to do that well. Okay, so they're supposed to look at them, at the evidence, and decide whether there's sufficient evidence to warrant a conviction. Okay. All right. So in theory, that's supposed to be an absolute power, but in some instances, political things mandate that you're going to have to take it to trial. Okay, so it's a big deal, highly on the news, either for selfish purposes or the DA wants to go on to higher office. That happens all the time. You're first a prosecutor and then you become a district attorney. I'm sorry, then you go for higher office. That's what happened to the current vice president, Kamala Harris, excuse me. She was a district attorney, okay, and that was her stepping stone to higher. Then she became, I believe, the attorney general, which is sort of like for the state of California, which is like the district attorney for the main law enforcement officer of the state. Then she went to the U.S. Senate, and now she is the vice president. Okay. The defense attorney, sometimes called the public defender, if you have one provided by the government, but you can also, if you have enough money, have a private one that you pay money. It's not till recently in our history relatively recently that the whole idea that if you can't afford one, one will be appointed to you. Okay, but obviously they represent the defendant during the whole shebang, right? All the pretrial stuff, once you get, assuming when you get it, and then through all phases, okay, up till if there's a conviction, then there's sentencing by the judge, right? Okay, there's some other ones. The bailiff, think of them as the law enforcement. They're sort of like generally speaking, they're a sheriff, right? Peace officers, they're in the court to announce arrival and departure of the judge, maintain order. So, like, if you've all seen the movie where the judge pounds his or her gavel and she says, "Bailiff, remove this person from the courtroom." Okay. The court reporter, they're basically, they transcribe, they literally type down what everybody says for the official court record. We've all seen the movie where the judge says to the reporter, the court reporter or stenographer, strike that from the record, right? So it becomes the official transcript of the court proceedings. And they use a special machine, apparently. It's some sort of, uses shorthand. I've never seen one. That's what I've heard. Lastly, the court clerk, that's sort of like the chief administrator, right? She sort of helps run smooth, makes the court run smooth. So, for example, if you're like in a traffic court, right, the judge is going to hear multiple cases a day, and so that person just kind of keeps it going, gets people ready, etc. All right? All right, so that's the end of the lecture.